for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penney.
So for those of you living under a rock, as I always say, there is a trial going on that started this week in Manhattan, in New York, of Harvey Weinstein, who is basically the mogul, the producer, the famous Hollywood guy that controlled a lot of films and productions, and a lot of individuals, including women, wanted to get on, become a star. So he, there's allegations that he was inappropriate with women during many years, and
it basically led rise to the Me Too movement.
Yeah, that's kind of where this all started. And this is really the first big trial. This is the criminal trial. Now, he settled cases, civil cases already out of this certain allegations, but he has pled twice not guilty to allegations of sexual misappropriation or misconduct. I mean, that's a broad term of all the situation. So the trial starts, and a couple interesting things occur.
And this trial is the one in New York.
New York. The minute the trial starts, or as they're going up to the courtroom, Los Angeles District Attorney, or the AG, I can't remember, I thought it was the DA or is it the AG?
It's the District Attorney.
Files more criminal charges against him in Los Angeles and Southern California. That, to me, I don't want to say, that worries me.
The timing of that just
as a
looks
lawyer,
little suspicious.
as a lawyer, that is not, that there are things that are being, you're aggressive as a lawyer, you do what's, best for your client, but the fact that they did that and the publicity went wild and crazy on that, now Harvey Weinstein's lawyer comes to court and says, Your Honor, we're about ready to pick a jury. Look, we need to put things in neutral until this all calms down. Why did the Los Angeles District Attorney's Office file this and announce it right as this trial was starting? And in my opinion, I don't like that.
Well, I think I know why, because Lacey, who is the district attorney, is running for re-election.
That's exactly what's going on.
So it almost looks like suspiciously like a political move.
So now we've got issues of legal wrangling in the Weinstein trial starting this week, because there's a number of things, but one reason is this DA down in Los Angeles County decides to go ahead and in my opinion, could taint part of the jury pool in New York.
There was another part that I want to sidetrack just for a second, because Weinstein's attorney brought a motion to exclude Gloria Allred from the trial, and specifically from watching the jury, the choosing of the jury. And the reason that it was is because she represents a lot of the other victims. And they're like, she should, and she may be a potential witness in this case. The defense intends to call her apparently.
Right.
So they're like, she shouldn't be there. And the judge said, look, she represents people that are witnesses and other potential victims, and we're not going to exclude her. So the judge denied that motion.
Got it.
Well, and that's interesting because it's a very common motion for both the prosecution and the defense to have what's called a motion to exclude witnesses. Anybody who may present testimony later on should not be able to sit in the courtroom and hear what other people say, so that when they take the stand, they can go ahead and say something corroborative to what was testified to. The beauty behind it is, if the stories are the same, they should be the same whether you were sitting in the courtroom or not. And so if they are going to call her as a witness, if they legitimately are, well, then, yeah, she should probably be out. However, if the court looks at it and says, you just put her on your witness list because you want to kick her out of the courtroom, and you don't entertain the actual notion that you're going to call her as a witness, so they can see through that. I could see maybe the court saying that she can't be in the courtroom during anybody testifying.
Right.
During anybody testifying that's a client of hers. However, However,
That's her client.
That's her client, and she has to be there to give legal advice. What if somebody's going to say something and she says, Your Honor, wait a second, I got to advise my client they could get themselves in legal jeopardy? That's why you have the attorney.
Right.
Right, and it's possible that this ruling only applies to the voir dire of the jury
Right.
Yeah.
and doesn't apply future-wise. But one thing the court said that was interesting is that he would presume that Gloria Allred would not be communicating.
judge.
The judge would not presume that she would be improperly talking to the other witnesses and telling the witnesses what's being testified to in the courtroom. He wasn't going to make that.
Well, I think that's interesting, the actual words that he used, that he is not going to presume
Right.
that she would do that.
Right.
Because the
Right.
defense was probably saying, she's just going to sit there and do that. And the court is saying, well, absent anything other, I have no reason to presume that she would violate her responsibilities and her conduct as an officer of the court. However, if after the trial starts it turns out that she is doing those things, that ruling may change.
But
That's true.
again, it's tit for tat here, and I think there's issues on both sides. But I truly believe the thing that does outweigh it all is if her clients are on the stand, even in a civil case, she should be allowed to be there.
Yep.
Like you said, Denise.
Yeah.
Absolutely.
And I think in the jury pooling and voir diring of the jury that it's appropriate for her to be there as well.
Yeah, I don't know.
That's my feeling.
Yeah,
With regard to this L.A. filing, the Constitution of the United States says the accused shall enjoy the right to a speedy trial. Doesn't give any time frames. And every state then attaches their own statute of limitations, their own, if you're arraigned, it's got to be within 60 days. Preliminary hearing has to be within a certain number of days. But the overall framework is it has to be the right to a speedy trial. I would see, I'm not saying it's going to be successful, but I would suggest and wouldn't be surprised to see Weinstein make an argument that the DA sitting on this case for as long as they did with no new information that would have justified the filing has compromised his ability to mount a defense and to try to get it bounced on speedy trial grounds. Not going to be successful probably, but I bet they make the motion.
Well, you know why they're doing the motion? For appeal. All this stuff they're setting up for appeal. And I'm going to reiterate it. We said it 2 or 3 times. Very interesting that this DA does it right as they're walking up to start the trial in New York.
Yeah, I find that interesting too. We need to talk about the texting and what happened in the
Yeah,
courtroom.
we got more on Weinstein when we're coming back.
If you pay my fee, I'll take your cake.
Radio Law Talk. Now back to the show.
So we're talking about the Weinstein case in New York that's going on and some very interesting antics that were going on in the courtroom. It's going to lead up to some motions that we're going to discuss in a second. But one of the things is about a phone. Denise, tell them about what happened with the phone situation.
Well, this judge is one of those judges that say no phones in the courtroom, period. No phones, no texting, no nothing. And Weinstein not only brought his phone in, but he brought 4 phones in. And during the picking of the jury pool...
No, he didn't necessarily bring them in. They had taken some of them. He keeps bringing... I just want to make sure we're clear. I don't think he brought all 4 in. He was using one of them, and they'd be taken away.
I don't know. It indicated that he was multiple texting,
maybe. I don't know.
And the judge caught him.
Right.
And the judge basically said to him, do you want to go to jail and spend time in jail for violating my order?
For texting, basically.
Yeah. And, Weinstein apologized and all that stuff. But come on, guys. I mean, if there is a court that says to you, a judge that says to you, do not bring your phone in and do not text or use your phone during these proceedings, you better honor that because they not only can they take away your phone, but they can put you in jail for violation because that is a violation of the court's order in front of the court. And the court doesn't even need to have a trial for that. The court can put you under arrest because it's basically a contempt matter of an order that occurred before the judge.
And I think it's interesting. I don't know if a lot of people consider this the position that a judge is put in, but when you're a judge, and again, I've never been a judge, so I'm hypothesizing here, but you're starting a high-profile case with the defendant who was arguably one of the most powerful people in Hollywood at one time, and you get the high-priced attorneys on either side, and everybody is scrutinizing everything that you do. I would imagine, as a judge, first and foremost in your mind is to establish exactly who's in control here and who who is laying down the law in the courtroom just so that everybody knows that you're not going to walk all over this person. And as a judge, you would have to pay attention to something that others might view as, oh, he's just texting. I mean, I can tell you right now, because I'm in court a lot, that if you took away the cell phones from every attorney waiting for their case to be called, who's probably over there sitting aside playing solitaire or free cell or whatever, if you took phones away from everybody in the courtroom, you would see professionals starting to go through withdrawals on any calendar that lasted longer than 45 minutes because they're all on them. And,
Right.
Yeah, but it's one thing to have attorneys that maybe need access to their calendar on the phone, to have them have their phones.
Yeah.
But another thing for them to be using their phones in court other than what's proper to be used
Why,
for.
at least while they're on the while they're prosecuting their case. If Todd, like, they're sitting back and waiting for their case, that's a different story. But
Well, actually, a lot of courts say no use of your phones, period.
yeah, no, they say most of them do.
Yeah.
But how many lawyers are down there looking at them anyway, right? Cal's got a.
Wouldn't Mr. Weinstein's attorney say, "Yo, Harv, put it away, buddy"? I mean, isn't that what you? How much money is the
They're
lawyer
arguing
getting?
they did.
They assured the court that they would make sure he would not have a phone on him in the future.
And not just for complying with the court's order, but we're in the middle of jury selection here.
Hello.
Do you really want to be these people that are going to decide your freedom? Do you really want to send to them the image that you couldn't care less about this, that you're going to be on your phone? I mean, I would think that jury consultants and attorneys would be like, if you want to win this case and have a snowball's chance and you know where of doing it, put the dang phone away.
Not good optics. Huh?
Here's a couple of things I want to bring up about the trial that I thought were interesting. That I know we don't want to beat a dead horse, but this is interesting. Yeah. Okay, when you do voir dire, that means when you're picking your jury, there's always a questionnaire. And the questionnaires are a couple pages long, 2, 3, maybe 4. The questionnaire in the Harvey Weinstein case is 16 pages long.
Oh, right.
Oh, is that all?
And not only that, at least the judge agreed to add the question to prospective jurors, questioning did they see any media coverage of the LA case while, before they came in. So that's a question that they ask. So to me, that's interesting. They're saying this is going to last 8 weeks, which is quite some time, which is going to take someone's time in life. But Denise talked earlier about the judge coming down on him saying, do you want to be in prison for, whatever, because of texting? So guess what the latest thing is? The latest is they've brought a motion. Harvey Weinstein's attorneys brought a motion to remove the judge, saying that the judge cannot be fair and impartial. They just brought it before, I think it was Friday or I don't know.
It was really recent, and the judge hasn't been able to decide that part yet.
Yeah, and so that's before them whether or not the judge is going to be removed because they're arguing the following, that Judge James Burke threatened Weinstein with jail time for texting, and then that is extreme. They're also arguing that he said, quote, you're going to end up in jail time for the rest of your life by texting. And bringing these prejudicial, inflammatory conduct and comments before the defendant, which has received widespread press attention, which is harming the jury pool, the Harvey Weinstein and the jury pool.
Now, look, when you file a motion like this, I have been in trials where the defense has filed a motion against a judge. The first person to hear it is the judge themselves. And the judge has ruled on it. He has said, I am denying your motion. I can be fair and impartial. Look, you run into a situation like this. We did a case not too long ago about the guy in Southern California that sent the
Ilke, what was his name?
Yeah, no. This was the guy who was trying to collect the debt for the couple who had water damage, and he was suing the insurance company.
Attorney.
And then the judge said, "You shouldn't practice law," and came back. So, look, if you're a judge and you want to lay down the law, you can do it, but you have to be careful what you say when you do it.
Right.
And in this case here, is it going to be more effective if you say, I'm going to put him in jail and you better do this, or would it be more effective for the judge to say, I see the phone is out. I have already issued an order, Mr. Weinstein. I'm holding you in contempt right now. Just do it.
Or not, no, just say it
You
in
know?
a different way. No, look, Mr. Weinstein, I've asked you before, and you are not complying. Please put that away. If not, I will hold you in contempt the next time you do it. That, period. Say it something like that instead of, you want to end up in jail the rest of your life by texting in violation of this order? Wait a minute. The rest of your life you're going to put him in for texting? Come on. Now, wait a minute. I want to finish this point.
Sure.
So then the attorneys are also arguing that this judge needs to step down because he's not allowing a cool-off period. And the cool-off period is because of this L.A. filing that we just talked about earlier. And I'll tell you right now, I'm kind of on their side. I'm not on Weinstein's side. I'm on the side of their attorneys saying there needs to be a cooling period. They're bringing up stuff like, Your Honor, there's online commentators that are well-known commentators saying, quote, and here's a quote from them, and this is all out in the press, just as they're starting their case because of this L.A. The one guy said, and then the cell phone thing went viral, right? And commentators are saying, and one said, quote, maybe they'll give him Epstein's cell phone to use. So stuff like that. It's kind of funny, but it's like that is evidence that this is going viral.
It is.
And give a cooling off period so it just calms things down because I don't care what people say about Weinstein. He's innocent until proven guilty, and that is our system.
Do you like the way that he's playing it up by using a walker and appearing to be very feeble?
Oh, yeah, there's definitely
he's playing it up.
He's walking pretty fast for a guy with a walker. I will say that the court, in addition to the motion to have him recuse himself, also ruled on the cooling off period request and denied that, saying, quote, hey, there's no time like the present. All sides are ready. The interesting thing with that, though, is when the defense makes a motion to have the judge recuse himself and the judge does not, the defense then kind of creates a situation now where they could try to appeal, saying, now the judge has grounds to rule against us and to be prejudiced against us because we've questioned his ability to be impartial and to try to get an appellate court to overturn that decision to appoint a different judge. When you make that request, you're kind of all in at that point. So we'll see what happens.
Yeah, so
you can play it both ways, it sounds like.
Yeah.
So believe it or not, whether you like it or not, we're going to follow this next week. Be prepared. We will be talking about it.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.